Well, good evening to all the attendees to this new event organized by the Iberian chapter of Ciarb. Today is September 21st, 2023, and it is 5 p.m. CET. I'm speaking from Southern Europe at this very moment. The Iberian chapter of Ciarb is part of the European branch, and me, Antonia Musategui Batalla, is here as my position of chapter's chair, and I will play the role of acting as moderator. This is the 7th event organized by the Iberian chapter, and with the help of our steering team this year, 2023. Let me thanks to the IT department of Ciarb in London headquarters for its support in all the communications infrastructure available for doing this event real. Today, we will discuss about the time bar clauses under FIDIC standards, and we will approach to the term to a specific view given from the Dubai International Financial Center Court. About the event scheme we are going to perform now, let me explain that it is scheduled to last 1.5 hours, maybe more, and will be divided into 2 parts. After my introduction, the main part, we will draft 5 issues with our panelists to discuss. The themes were: what was the purpose of the time bar? What was the purpose of the time bar clauses? Second, the hypothetical example in paragraph 45 on Panther's award, and if the Dubai International Financial Center Court justified in taking such a strict view. Strict is probably, it seems that strict is a hard term, but sometimes others have mentioned to this as a draconian regime. That's one we're going to talk later. The third issue is how realistic would it be for contractors to comply with clauses 20.1 of the on the Dubai Court's interpellation. The fourth, what to say about Dubai principles of good faith and reduction in liquidated damages. The fifth, how likely is it that the same approach would be followed in international arbitration from a realistically approach. Finally, we will ask, and connecting with the second part, for having other issues as to the claim notices and LD provincials, liquidated damages provisions, commonly encountered in international project disputes. And then we'll connect it with the last part, related to Q's and answer, which we're answering questions posted by the audience. Before I introduce our panelists, let me briefly go over a few housekeeping rules. As per registration of information, the first I should mention is that this event is being recorded and eventually also transcribed for the attendees. If they are present here, it implies that they accept both actions. And for those interested in taking part in the event, let me mention the 2 ways to proceed in these regards. First of these, using the chat button you can see in the red part and in the below and the low part of the screen. That is for general discussion, and for collect any technical issues they would experience. But please do not use it for the chat one for making cues addressed to the speakers. For such function, apply to the Q&A at the bottom of your screen to ask your questions to the speakers. Notice that possibly your queries or questions would have been answered along the discussion. Then I will omit it. But if not, I do my best to ask aloud in the last part of this event. Will probably suggest attendants to perform their cues out loud to the audience if relevance for detailed explanation. Even in such cases, if the attendees who write the question would like to explain it somehow, please raise hand. And now, going to the next issue, let me present or introduce our speakers. Starting with Slava Kiryoshin. Slava is an English qualified solicitor advocate and has been based in the United Arab Emirates for more than a decade, advising clients on energy, construction, and infrastructure disputes throughout the region. His clients include national and international oil and gas companies, refining and petrochemical companies, APC contractors, I mean engineering, procurement, and constructions contractors, and oil and gas service companies. Slava is ranked by Legal Directory Who's Who as a global leader for power and electricity and oil and gas, describing him as having, quote, a wealth of experience, at quotation, and being a standout layer for, quote again, his dispute resolution practice in the oil and gas processings, refining and petrochemical infrastructures in the Middle East, end quotation. He is also ranked as one of the UAE leading answers for both construction and oil and gas in the Legal 500, where anonymous client testimonials praise Slava of having, quote, excellent industry knowledge and being, quote again, very experienced in Middle East. There's another sign of relevance in who expressing these terms. Slava is probably the best person that we have worked with in the recent past. He understands what we need as a business, commercially savvy and technically great. His strategic advice is always welcome by our board of directors. So then, what to say less than welcome, Slava, and thanks for joining us today. And now, let me introduce to the second speaker, Mehmet Karakok. Mehmet is a managing director with Secretariat and is based in London. Mehmet is an engineer and member of Ciarb. Has 18 years experience in the construction industry, specializing in dispute resolution, delay and disruption analysis, contract review, preparation of claims, quantum and programming matters. In addition to the projects in the UK as a civil engineer and expert, he has undertaken commissions in more than 30 countries. Mehmet has been appointed as a delay and quantum expert on many occasions, both as party-appointed and a tribunal-appointed expert, and testified several times in arbitration proceedings, including giving concurrent expert evidence. Who's Who Legals recognizes Mr. Karakor in its construction expert witness from 2019 to 2023, and also in consulting expert. And regarding arbitration expert, his has been recognized in editions 2021 to 2023 categories. And it says precisely about Mr. Karakok that combines powerful cognitive skills with outstanding performance on the witness stand, and his experience in construction cases is second to none. Again, thank you, Mehmet, for having you here, and expecting from listening to you and from Slava about the terms under discussion. Finally, and but not least, Natalia Barroso. Natalia Barroso is an engineer and a fellow of the Chartered Institute of Arbitrators with significant experience in international construction arbitration. Before she got involved in delay analysis for dispute resolution purposes, she worked as a project engineer and lead planning engineer for over 16 years in engineering and construction mega projects. Since 2016, he has assisted the appointed delay expert witness across a broad spectrum of energy, oil and gas, mining, and infrastructure projects. Nowadays, she performs as director at FTI Consulting in Dubai, United Emirates. Natalia holds a degree in mechanical engineering by the Universidad Politécnica de Madrid, a Master of Law in the Robert Gordon University, and an MBA in the Instituto de Empresa Business School. And Natalia, with significant roles in the steering team of our Iberian chapter, has also led and organized with the Ciarb Fellow Abdelkader Kaladi's support and suggestion for this event. They suggested the speakers panel explain the relevance of the subject and weighted reasons to performing the event here. Abdelkader, due to qualified motives, could not finally come to the panel. Still, let me give to both Natalia and Abdelkader the recognition they deserve for the initiative and the great fulfillment work has performed today. Now, the main part is goes with the first issue, which is well, previous. We are going to talk about two about FIDIC standards, and I collect to mention this about the FIDIC standards. They have been said that the current suite of contractors, rounding the term of FIDIC, is marketed as being practical contracts with common sense clauses incorporating the best in engineer practice, and that's fine. The point we are going to talk along this hour and a half, or more maybe, is to answer an apparently easy questions. When late is late? So then, first issue to discuss about. What is the purpose of the time bar clause altogether? Is it more important to focus on the contractual language or the mischief with the clause is seeking to avoid? So we can start for whatever you prefer to start it. At your ease, Natalia, Slava, Mehmet, what to say about this?
I'm quite happy to start on this one because as a common law lawyer, way out of his depth in a civil law event, I think if you were to ask a common law lawyer this, which you did, we would always say that the whole purpose of a time bar clause is to make sure that the employer has an opportunity to withdraw their instructions or amend their instructions once they understand that something that they have done or something that has occurred is likely to lead to a delay event. So that's kind of the whole point of it. But over the course of practice, we tend to find that employers abuse this language, and they really do abuse it by looking straightforwardly at the words and basically saying, look, this is a very strict requirement, and if you don't comply with this requirement, then your claim is not valid. And then that's kind of fine and well to understand that position. But at the same time, you have contracts which they're not drafted in a vacuum. You know, the whole purpose of having a contract is to record the commercial relationship. So it shouldn't be at the expense of an academic or strict legalistic approach to deny valid claims. And to my mind, whilst there's debate on this, to my mind, it's probably more important to focus on the mischief by which this clause is seeking to avoid. So the whole point of it is to make sure that everybody is aware that there is a delay event. And that's the whole purpose of the notice, or the time bar of a notice. I don't know, what does everyone else think?
Yeah, so I totally agree with Slava. Ultimately, the purpose of a time bar provision is to ensure that the employer is given timely notification of events that may adversely impact the contract price and or time for completion, right? So that's really the starting point. However, it's true that sometimes there are conceptual difficulties in effectively implementing time bar provisions. So in other words, the confusion starts when one party is willing to implement the provision for the benefit of the project or for benefit of the parties, whereas the other party resists on that. So that's why, in my experience, whether the time bar provisions really work as an early warning under FIDIC contracts or other standard form of contracts, and whether they lead to a fair allocation of the risk will really depend on the employer and the contractor's approach in administration of the contract. So on one end of the spectrum, a lack of notices might be used by the employers or engineers to muddy the water and take the issues away from the facts or the bigger picture, especially when the contractors had legitimate claims. And on the other hand, the early warning notices, if they are used appropriately, might allow cost-effective solutions at an early stage, and this might prevent significant delays that might have occurred in the absence of an early warning notice. Let me give you an example to expand on this point. Let's imagine on a hypothetical case, employer changed the manufacturing specifications of an equipment, but this impact could be mitigated through, let's say, additional shifts during the fabrication in the factory, right? So if a timely notice is given, right, by the contractor, explaining the employer that this would have delayed the manufacturing of the equipment, and if the employer agrees that as a result of its change, this happens, but also if the employer agrees to cover the cost of additional shifts, then the delay, the potential delay, or at least an element of that delay could be mitigated. So in this case, then it will be a win-win for the both parties. The employer's project would still finish on time. B, the contractor would not incur additional, let's say, prolongation costs, right? So this shows that if the notices or the early warning notices are used properly, both parties may benefit from this situation. So these are really my views. So, okay, we understand why they are there, but in practice, they should be used for the benefit of the project and for the benefit of the parties, rather than creating obstacles for one of the parties.
Natalia, what to say about this?
Well, yes, as my colleagues, they just mentioned, the primary purpose of the 28-day time bar clause in FIDIC contracts is to encourage contractors to promptly notify to the other party, usually the engineer or employer, of any events or circumstances that may give rise to a claim. This timely notification is essential for initiating the claims process and allowing for a thorough investigation. The clause aims, this clause, the 20.1, aims to ensure that the party receiving the notice has the maximum opportunity to investigate events and its impact on the project. This investigation is very important for determining the extent of any delay and evaluating whether it can be accepted, mitigated, or avoided, as just explained Mehmet. And now, if we move a little bit, one case that is the Obrasco Nuarte Lines Sociedad Anónima versus Her Majesty Attorney General for Gibraltar, which this case has been very important. The judge, Akenhead approach to interpreting time bar clauses under FIDIC contracts aimed at achieving an equitable interpretation aligned with the contractual intent. And because of that, he did not strictly interpret subclause 20.1 against the contractor interest. Akenhead interpreted that the contractor has the choice of giving notice of a delay when it becomes evident that a delay would result from the event, or at a later date when the delay had already begun to be felt in the works. Akenhead believed that the scope of the subclause 20.1 should be reasonably broad, considering its significant implication for potential valid claims, including those arising from breaches by the employer. This interpretation allowed more flexibility for contractors in providing a notice of delay. It is noteworthy that the FIDIC 2017 contract acknowledges the potential hardness and unfairness of the time bar clauses, as for example 20.1 with the 28 days, deadline for notifying the claims. And it introduces the possibility for a time bar waiver if the late submission of notification is justified. This change reflects the industry awareness of the challenges posed by the subclause 20.1 and aims to provide some relief to the party making the claim.
Mhm. Okay. So any comment in regard? So if not, we pass to the second issue. The next question for the panelists to comment. Example given by paragraph 45 in Panther case. Is the Dubai court justified in taking such a strict view? I mentioned the term draconian regime sometimes has been comment about this decision. Do you agree with that? Was a draconian decision? I don't know if Natalia?
Yes. Yeah.
This time you. Okay.
Yeah, okay, let's start this now. Okay, in paragraph 45 of the decision, the judges in the DIFC court commented on the approach by J. Aikenhead of OHL versus Gibraltar, the case that I mentioned before. As I said, the Aikenhead approach to subclause 20.1 was that the contractor has the choice of giving a notice of delay when it becomes evident that a delay would result from the event, or at a later date when the delay had already begun to be incurred. However, the DIFC judge in paragraph 45 illustrates a hypothetical case to explain why they disagree with the Aikenhead's viewpoint. They described how in a 3-year project, if a delay event arises in the first year of the project that caused the works to take an extra month or two in the year 3, the judge's view is that there would be no actual delay to the time for completion until then. And because of that, the delay notice would only have to be given within 28 days in the year 3, when the time for completion passes, without the works being completed. And subsequently, the DFC judge was that the Aikenhead approach was ineffective for its purpose. The DFC judge's example doesn't make, in my opinion, doesn't make sense, because in reality, a project can experience a delay right from the day one if this delay is on the critical path. A delay doesn't need to wait until the official completion date. Because of this, the DFC judge, my opinion is that they misunderstood the perspective from Aikenhead to subclause 20.1. This is my opinion.
I think I agree with you, Natalia. I think that the whole premise of the DIFC decision was somewhat contorted and maybe a bit tortured, actually, the way that they looked at it. Because the whole point that Aikenhead was trying to make in the case was effectively, look, a delay may arise, but you may not know that this event will lead to a delay. And in fact, it might not at that point actually be leading to a delay if you look at it schedule-wise. I mean, I'm not a programmer. I'll leave that to you and Mehmet, of course. But if you just think about the logical scenario, something happens, and if I don't believe that it's going to impact the actual date to complete the project, why would I give notice about it? I genuinely don't think that it's going to have an impact. However, the DIFC courts perhaps took a hammer or a sledgehammer to crack this walnut, and I just don't think they've done Aikenhead's nuanced position justice in the decision. Personally, I think he was correct in trying to achieve a common law, equitable regime, but you know that wasn't the case in Panther, in my opinion. I don't know, Mehmet, what do you think about this?
Right. So first of all, I should apologize from the audience, because now they get a group of panelists all agree on almost everything, right? So maybe Antonio can disagree with us, but I agree with both Slava and Natalia, and I'm not a lawyer, but at least from a delay expert or engineer's perspective, in my opinion, this is a misinterpretation of Aikenhead's decision. And at least from a programming perspective, it appears that this interpretation in Panther case did not really sufficiently consider how delay claim should or ought to be assessed. So extension of time requests should be dealt as the issues arise, and this is the industry advice, including the Society of Construction Law Delay and Disruption Protocol. And as Natalia explained, if an event is likely to cause delay to the critical path activity, and there might be some very limited number of exceptions, but normally time for completion will be delayed unless the delay is mitigated. Therefore, it will not matter whether at that point in time the contractual time for completion had already been exceeded or not. Okay. And also, in my opinion, the approach suggested by the DIFC's court or their decision will be in practice unlikely to be a satisfactory solution for the parties, given the uncertainty around the potential impact of a large number of delay events on complex projects, because on one project there will be a lot of things happening at the same time, and they can't really expect a notice provided for every single issue, irrespective of whether it might cause a delay or whether it is significant or not at that point in time. If this will be the approach taken, then to avoid the risk of losing an entitlement, contractors will start sending tens of notices without any proper investigation of the events, and even more importantly, possible mitigation solutions. I don't think that is the purpose of the notice provisions under the contracts. And then employers or engineers will not make they will not make a determination on anything, because they will say, okay, you send the notice, but let's wait and see. And they will try to stonewall claims by asking more and more details. So in short, the focus will move away from the more important day-to-day issues of a project for successful delivery of that project. The focus will be just a claims culture, whether the notice submitted on time, whether you follow strictly what the contract provisions require from the DIFC's perspective. And in that case, of course, this decision will not be justified, because the importance is the successful delivery of the project and resolve the issues that will allow that to be happen. So this is my humble view.
Mm-hmm. Well, what to say? I don't know if you have been awarded about a question we received recently. Long one, I asked the anonymous attendee who brought the question, then asking him if he would like to. Previous one. This is a step back, because he asked about FIDIC, saying FIDIC stipulates that the contractor is required to provide a notice when they become aware of, or should have become aware of, a specific event. So then, I mean, we are stepping back to the first issue. And this anonym asked to clarify, can you please specify which of the following scenarios is considered as the triggering point for giving notice? I don't know if you would like, and put 4 stages. I don't know if you would like to comment to this, or wait to the last part, or advance to him or her, the anonymous one, that we are going to deal about these issues in the following questions, the following part of the main. Let me revise this. I don't know if you would like to comment now or no.
I can potentially comment on this. Was the question basically when should you send the notice under FIDIC?
They want from you to match with one of the 4 different scenarios he or she has drafted in the question. About the triggering point to giving notice from the contractor to the engineer as to launch the effects of the clause 20.1.
I think under FIDIC, if you were to look strictly at the wording of FIDIC, the triggering point is basically when you know that there is a delay to the critical path, or if I remember correctly, it's basically when your entitlement arises.
Mm-hmm.
So the whole point is that you need to be aware that there is something that I'm going to ask for later.
Mm-hmm.
And that varies. There isn't any real set guidance on this. Obviously, if you see a delay event which you know is going to impact the critical path and move your time for completion,
mm-hmm.
then yeah, at that point, that's when you send a notice.
Mm-hmm.
But if something happens and you just don't know the impact that it's going to have on your project at that time, you would only be required to send a notice once you understand that, yeah, there will be impact, and yeah, I will be asking for entitlements for either time or money. I mean, that's my view, and I think that's more or less commonplace. I don't know, Mehmet, Natalia, I saw you nodding. I don't know what you guys think about this.
I see. Mehmet?
Yeah. Well, just probably the only point to add to what Slava explained is the process, the claims process, at least under FIDIC, is an ongoing process, right? So there's no harm to give an early warning or send a notice even at an earlier date than when you believe you, let's say, you are entitled to additional time or cost. But then I believe the more important part is to, let's say, give a concrete answer. Okay, what will be the impact or likely to be the impact? Because that is really what will matter for the employer eventually, whether that variation or instruction will be still given after the, let's say, understanding the potential impact of that instruction, or whether there is any way to mitigate potential impact of that change. So the way the FIDIC works, I think, allows the parties to assess the situation as they get more information, and I think that shouldn't be forgotten. It's not really just giving a notice. I believe for, again, the successful delivery of the project, the situation should be assessed as the things get more clear.
Mm-hmm. Well, what to say? We could think that probably this part of the conversation would connect with the third issue. How realistic would it be for contractors to comply to clause 20.1 in FIDIC standards? And connected with that, the case of Dubai court's interpretation. Have to say something related to this and then connect with the third issue?
If Natalia and Mehmet allow me, I'll try to tie all of the issues together very briefly, which you don't usually get from lawyers these days. I genuinely believe that a lot of academic lawyers think that clause 20.1 and similar kind of more bespoke clauses, that they actually exist and they're easy to comply with and everyone should do it.
Yeah.
I'm not defending contractors from not sending notices, because there's absolutely no reason why a notice shouldn't be sent. But you also have to look at the practicalities. You also have to look at culture of some contractors. For example, I've seen situations where a contractor was sending too many notices in the eyes of the employer. So the employer complained to the contractor's management, and this project director was removed. But all he was trying to do was follow the words of the contract, and he was taking a robust view and saying, okay, something happens, I'll send a notice. I need to cover myself in case I ever need to rely on this. But he got let go. So when you talk about the practicality of this and the way in which the DIFC court's decision it kind of leads to this situation where you almost need to hire somebody full time to just send notices once, twice, 5 times a day. I just don't think it's realistic. The whole point of it, and Natalia and Mehmet quite clearly outlined this from a more practical perspective, is you need to deliver a project. And from a legal perspective, all you're really trying to do is to notify the employer that I'm going to be asking you for something because of this. That's really the best way of looking at it. Trying to split hairs or getting very academic as to notices, I don't think people will appreciate this when they actually go to a live project on the construction site and see what kind of a situation you have day to day. It's just not possible to capture everything in the notice.
Right.
Mehmet.
Yeah. So I think we need to see the bigger picture. So, of course, the contractors on multi-billion-dollar projects, they might have the resources, or the owners with big pockets, they might have the resources or might hire the engineers to, let's say, follow this, the contract A to Z, sending notices, tons of notices every day. But the same provisions are also applicable for relatively small subcontracts, or just they could be really a very small work package, but back-to-back provisions of the main contract dictated on a subcontractor. And then in those circumstances, I think it's really unreasonable for that subcontractor to have those resources. And if that will be the expectation, of course, the cost of doing that work will be higher, and the contractor will reflect that to the employer. And eventually, someone will need to pay the cost of this, right? And secondly, again, from a practical perspective, there are certain issues where you can clearly say, look, it's either A or B, and if you like me to do A, this will be the impact. If you like me to do B, then this will be the impact. But often issues are interconnected, and it's like a chicken and egg problem. You need some information from the employer, then you can, let's say, notify them. But equally, even when you give the notice, that doesn't mean the issues are resolved there. It's just an ongoing process, and that is how a project is being built. This is not like let's say a factory or a manufacturing process. Almost every single construction project is unique, and the issues will be unique. So the notice provisions, I think, should provide some at least flexibility, or the parties, even the standard forms are followed. They should understand that there needs to be some flexibility, and again, eventually, in most of the projects, the parties find a way to implement this, in an effective way.
Natalia, I don't know if you would like to say something related to the. If not, let me review some of the comments drafted in the.
Can you hear me?
Yes, I can. Yes, yes.
No, I would like just to follow with this. That I think I agree with my colleagues that the approach requires that the contractor they need to send this delay notice in 28 days. I find it this perspective quite subjective. In my opinion, is that this interpretation doesn't work, doesn't seem very workable. Essentially, it could lead to a substantial rise in the volume of letters, as my colleagues, they said. Many of them, they are not relevant. This approach doesn't align well with the practicality and efficient contract management that construction projects require. Throughout the duration of a project, there is a significant volume of daily correspondence being changed every day. And this constant volume of letters can be very challenging. And many contractors and subcontractors find it difficult to control all this communication. And also it is very challenging to respond all of this in timely manner. So this will create, if now people try to follow this this approach, because all the contractors will be fearful of to all those claims to be rejected. This will create a high number of letters. Most of them will not be relevant, and the situation of a normal project will get worse. And because of that, yeah, I think that I agree with my colleagues that due to the complex nature of the projects, this approach or this requirement, to be strict to this requirement, will make an extra burden and expense to contractors.
I see. Well, have several comments in here. Let me select some of them. If you would like to answer in the directly, lively. For instance, anonymous attendee. Although this webinar is related to FIDIC, if we compare FIDIC with NEC contracts, in the last one of the PM engineer will consider that an EW was given even though it was not. Is it the same in FIDIC? Any of you would like to give an answer? Was posted at 1736.
I mean, I'd be interested to hear non-lawyers' views on this. And having been based in the Middle East for over a decade now, NEC contracts isn't something that we see very frequently. I think I know the answer, but I see Mehmet as also chomping at the bit to say something about it.
Right.
Mehmet, the ball is with you.
Yeah, yeah, it's interesting that one of our colleagues mentioned about the NEC contracts and the early warning notices. I think NEC contract and FIDIC NEC and FIDIC contracts, at least from my perspective, being a non-lawyer, they are different in NEC mindset. There is more collaborative approach, and even let's say the contractor doesn't provide a notice, if the project manager believes that early warning might result in a compensation event, the project manager might advise the contractor to provide the notices. So I don't think we can exactly compare FIDIC and NEC from that perspective. And also I don't believe that in NEC contract giving an early warning will be sufficient for an entitlement to a compensation event or additional time and cost. So I don't know whether this answers the question. So in short, I don't think they are same in FIDIC.
I think from my memory, because yeah, I've been based here for for 3 years, but yeah, NEC contracts are more collaborative, and they try to resolve the issues contemporaneously. They are done contemporaneously along the life of the projects. Then try to settle these things. So yeah, I think it's quite different.
Well, I've seen a comment from Bamsi Krishna. The last one. Red. In contract terms, when we say that the delay notification should be issued within the stipulated frame time by the contractor upon his awareness on the occurrence of delay, what should be the important content of such a notification? Delay impact in days should be mentioned. Second, is there a need to mention the word delay in the subject or body of the letter? Very formal here. Or, sorry, or the contractor's intention of the letter should be clear to the engineer, wherein the delay word might not be used. Finally, Vamsi said, also, do we need to explicitly refer to the contractual clauses against which the notification is being issued? What do you think also? Is the kind of concern of a practitioner with very little or very much experience in legal. I mean, not bad for Vamsi. It sounds like it was a kind of discussion between legal and non-legal practitioners involving how we interpret the conditions or the clauses in a contract or an agreement, together with the experience they both respectively take to wrap the thoughts and mind and interpretation.
Yeah, I think to answer that question, it's and it's going to be a very lawyerly answer, unfortunately, but it will depend on what your contract actually says. I have seen clauses that required specific wording to be written in the notice. I've seen contracts where a specific clause had to be mentioned when you are sending a notice. And I can't remember off the top of my head the case, but there is a case from the English courts, which basically says that if a contract requires you to send notice on pink paper, sending the notice on blue paper would be completely irrelevant. So, you know, you have to bear that in mind, that from a strict perspective, it is what you've decided to do in the contract. When we get to the reality of these things, I mean, we'll probably cover that in some of the latter parts of our discussion, but the reality of these things is very different to what the contracts say sometimes.
I see. And Natalia, I've seen you introducing an answer somewhere.
Well, yes, I'm just reading a little bit the answers and trying to respond them. For example, there is one question. They're saying, is the employer not aware when he's making a change? I think this question is a little bit strange, no? Because normally engineers or employers, they are aware when they are making a change or when they are having a delay event. Yeah, they should. Yeah, I don't understand.
Yeah. But as Slava mentioned, I think we'll just touch on this point, and the interesting articles about this topic, and probably it goes to duty of good faith as well, although that's not a recognized, concept under English law, at least under, I will say, most of the construction contracts. It may, of course, be different for employment contracts or some other forms of contracts, but we'll come to that point in short.
I'd also wouldn't overestimate. So I wouldn't necessarily assume that all employers know that they're making the change. I have seen some ridiculous situations where people were 1000% convinced that what they were asking for was in the scope of work. So they were just insisting on it. And it wasn't, 3 years of arbitration and $10 million in legal costs later that they realized that actually this was never part of the scope of work. So yeah, don't overestimate employers. Most of them, especially on the bigger complex projects, this will be the first, potentially their only large-scale construction project that they will do in their organization's history or existence. So yeah.
Well, let me tell you this. Due to the case that this point the conversation is getting hot, Eugenio Zopis is asking us to allow him to speak. Let him speak to listen what he wants to tell us. Eugenio, the micro is yours.
Hello, I would like to know, thank you very much for this very interesting webinar, first of all. I would like to know whether there is any further defense that could be raised as regards to late giving of notice. For example, unconscionability. Is it possible that the employer instructs a variation, and this variation cannot be paid fairly, simply because the notice have been given too late? I would like to know the opinion of such distinguished speakers. Thank you.
Thank you, Eugenio. Well, you three, Slava, Mehmet, Natalia, who collect the challenge?
Unless anybody wants to go first, I assume everybody's going to throw the lawyer under the bus, right?
Right.
Okay, so look, there are many defenses to time bar, generally, and my view of it, and this is my view of it, is that there are three potential scenarios at which you need to look at. Scenario number one is, where are you arguing about this time bar? Are you arguing in the court, or are you arguing in arbitration? That's scenario number one. Scenario number two is, are you arguing under a civil law regime, or are you arguing under a common law regime? And those things matter. And I guess scenario number three is, if you are in arbitration and you are under a common law regime, who are the arbitrators that are deciding your dispute? So generally speaking, if you're in common law, and in my part of the world, in the Middle East, there are plenty of arguments that you can make to say that the time bar provisions are actually too restrictive, they're unconscionable, that, you know, sometimes they're contrary to public policy, you know, it's a way of unjust enrichment, etc., etc. In reality, I've rarely seen a time bar defense being successful just on its own. So if you have a time bar defense against very black and white and meritorious claims, so if you have a good claim and the only real defense the employer has is basically you were too late in submitting the claim, I haven't seen that stand up much in arbitration these days. Even if you get to the English courts, I mean, until perhaps Aikenhead's decision, it was more strict. It really was more strict, and Aikenhead kind of opened the doors there to you know, to help the industry, because the way that these provisions were being interpreted, whilst they were legally correct and perhaps, you know, academically perfect, they were stifling business, and that's not a good thing. The law is there to support transactions, to uphold certain principles, and I'm talking about the commercial law, not, you know, human rights or criminal law or anything like that. I'm talking about contracts here. The law on contracts exists to support business, and having seen these types of provisions basically defeat very good claims, it just wasn't helping anyone. So pulling all of that together, there are many ways in which you can circumvent a time bar. However, your chances are significantly worse if you were to go to English courts than if you were to go to arbitration. And your chances are worse if you were to go to arbitration under a common law regime as opposed to a civil law regime. So that's my summary. I don't know if anybody wants to add to this.
Natalia, Mehmet, something to add from your perspective?
But probably I'll give a lawyer's answer, but the contract would also matter, you know, the precise wording of the contract, and also the how the parties basically implement the requirements of the contract up to that point. Because if it was the case that in a way, one way or another, the employer or engineer never required, you know, notices for, let's say, acceptance of the change orders or additional works, and suddenly they use this as a defense, you know, by act, you know, they waive that requirement throughout the project, and, you know, again, this could be used as a potential defense against a time bar provision.
Mhm.
Also, I think there we have like a question related to this issue that touch a little bit on this issue.
Mhm. Well, so let's continue, but two things first. Many of the questions I still have here, we're going to revise for the last part of this event to not to introduce more delay than we have. Second, as you can see, if you are appealing to explain your positions aloud, don't prevent yourself of raising hand and asking for permission. I'll be delighted, and probably the Slava, Mehmet, and Natalia would be also delighted to answer you live. Then, so returning to the stream course of this conversation, the fourth issue is about the Dubai principles of good faith and reduction in terms related to liquidated damages. What do you have to say or to think or to explain or comment about this issue? Either you three speakers. Slava would like to start?
Sure. I mean, just to kind of give some context to this question, it's a slightly loaded question because in the Middle East, not just in Dubai, but under the Middle East legal systems, there are generally there are generally provisions which basically say that a judge is at liberty to revise the amount of liquidated damages based on the actual loss suffered. And there is a similar type of provisions under the DIFC contract law. So for those that don't really understand the difference, the DIFC courts are basically common law courts within Dubai established in the free zone, and they have their own legal system. So they have a contracts law which effectively says that, you know, if the liquidated damages are unconscionable or disproportionate, then they can be revised. I think the actual words is used is if they are grossly excessive in relation to the harm, they can be revised. But the DIFC court basically didn't touch upon that principle too much. They simply said that, well, no one raised the point that, you know, LDs were unreasonable, which as a lawyer, it leads me to the question of, well, does that mean that it could have been raised as a point and it would have been reduced for liquidated damages? And the principle of good faith is a similar concept that that is mentioned in the DIFC laws, albeit that it says good faith needs to be expressed rather than implied. And in contrast, the principle of good faith is basically throughout the Gulf region. It's almost enshrined in all of the civil codes. I mean, it is the corollary of doing business. So everything should be done in good faith, whether it's your performance of contracts, whether it's your interpretation of contracts, or even just general business dealings, everything should be done in good faith. However, the judges in the DIFC case basically gave a fairly brutal and robust judgment. They said, we're not going to imply good faith when you guys have agreed to a contract. And that's the end of it. And the contrast of this position with the rest of the Middle Eastern legal system, if I can even call it that is quite a big contrast for me. So in essence, I think the DIFC courts have taken perhaps too strict of an approach to a well-established principle. And I'm not sure if that's going to do them good in a construction context.
Yeah.
Mehmet,
Sure.
something to comment?
Yeah, so again, although I'm based in UK, I've been involved in disputes all around the world and mostly civil law jurisdictions, and the possibility for reduction of LDs, that's an approach taken by many arbitrators, especially in cases where they believe that that provision does some injustice to the parties suffering from that. And I mean, just as a layman, when we refer to good faith, I think the starting point that will be someone should not benefit from his or her own fault, right? So in other words, you know that you are preventing the contractor, for example, from completion of the works on a timely manner. And since the contractor did not provide the timely notice, and you didn't take, let's say, any mitigation measure at all yourself, you are aware of this situation, it is really difficult to understand, whether what from a good faith perspective, what is the loss suffered by the employer when it's knowingly causes delay to the project and doesn't take also any measure. So in those cases, it's difficult to let's say adopt the good faith principle and justify the decision made by the DIFC court. Similarly, I think one of the audience colleagues asked about a question: what if the employer knows that it is causing the delay? Why the contractor should submit or issue a notice for that provision? And Slava explained that in some cases, genuinely, the employers believe that, that wasn't an additional work. This might be because the specifications may not be clear, or there might be a number of stakeholders involved in the project, and the employer might think that was the responsibility of one party instead of the other. But Professor Doug Jones has an interesting paper on this, especially in cases where, it's almost clear from the outset that it is an obstruction or hindrance or prevention of an employer to contractor's work. It is difficult to really justify the loss of entitlement to time or money due to absence of a notice. I will recommend the audience to read that paper. It looks at the issues from both common law perspective and civil law perspective, and that's an interesting paper.
Mm-hmm.
Yeah.
Wouldn't you remind just not a comment? The paper of Professor Jones. Wouldn't you please repeat the title?
I think, Mehmet, you are referring to this paper, Prevention, Time Bars, and Multiple Construction versus Honeywell Control
That's
System.
That's it.
Yeah.
Okay.
Is that one, no? Yeah, because I read this paper and I found that it's very interesting. And in order to answer this question, I had a look to this and I took some ideas. For example, one of the ideas is that from a point of view of trying to apply liquidated damages in a situation of complying with a delay notice, how can we justify this when the employer is aware of the delay they caused due to their action? Should they still have the right to apply liquidated damages in this situation? For example, we see that also maybe as Slava said, that there are some cases that maybe the employer, they are not aware that they are instructing a change. But also there are situations where they are employers that they are very sophisticated and they know really well if when they are issuing instructions or changes, and they know really well they are causing critical delay to the works. In this case, maybe they shouldn't be entitled, or they shouldn't be allowed to comply to comply with the issue of the delay notice in order to make the contractor to apply liquidated damages. Also in this paper, they mentioned that to try to apply the liquidated damages when the contractor fails to comply with the 28 days notice, it makes the contractor fully responsible for a delay that was never caused by them, as it was from the beginning the employer who caused this delay. However, because the contractor, they just failed to comply with the delay notice, this approach makes the contractor fully responsible for a delay that they never caused. And because of this is totally unfair. It could be said that the contractor did not stop the delay, and therefore, in any way, maybe, and in any way they caused this delay. And this situation could be treated as give time but no money, because in order to allow the employer not to take advantage of their own wrongdoing, and following the prevention principle, the employer would lose the right to claim liquidated damages. And also with regards to the reduction of the liquidated damages with the Article 122, I think Slava, he covered quite well this point, and I think I don't have anything to add.
That's it. And precisely, many of the revised in the questions posted along the second issue, many of them somehow was related to precisely consequences of Article 122 or conditions. If you would like to review the post before entering the last of the fifth with the last issue, you could also consider if you would like to respond to someone. I mentioned one of them in special because I've seen that an anonymous attendee asked something about sounds interesting. No, it's not here. There was someone who asked, can see now, what was the award or the Dubai decision about which you were talking about, who opens the door to a more liberal interpretation? And I think we have been rounding the decision of Dubai, but have not explicitly identified such a kind of decision or the case. Will you please remind to the attendees the case about we are talking about regularly, who opens the door for a more liberal interpretation of the clause?
So I think you're referring to OHL in Gibraltar, but
Yeah.
that wasn't the Dubai case.
Yeah, that is Water versus Gibraltar in 2015, if I'm not wrong.
2014, I think. Yeah.
Yeah. Okay.
Actually, it seems like one of the attendees put the full name of the case. I don't know whether the audience can see
Citrus,
the answers. Yeah.
That is. Thank you, Cyrus. Cyrus Titus Aumu. Hope I said right. Well, okay. Now, last of the issues, the fifth one, which is related to, how likely is it that the same approach would be followed in international arbitration?
Yeah, I think I've touched upon that one before already. But realistically, whether I'm appearing as counsel or sitting as an arbitrator, I think there was only one case that I've come across, and here I speak on the Middle East region. I'm not talking about international construction arbitration at large worldwide. I'm only limiting it to my experience and practice where I'm based. But effectively, there's only ever been one case where I've seen time bar being applied very, very strictly. And frankly speaking, that case was effectively hopeless. There was just no merit in the contractor's case anyway. So the arbitrators got around the issue fairly quickly and just said, as a preliminary issue, all of these claims are time barred and here's your final award. Whereas everywhere else, the arbitrators will try to take into account the whole factual matrix. So they're not just going to simply say, okay, well, this happened on 1st of January. The notice came in 23rd of January. Therefore, you're either 1 or 2 days late. And let's have an argument about how many days it is. Therefore, we're not going to award you, this EOT claim and a couple $100 million worth of prolongation costs. That's just too unrealistic. And the parties in their council are generally very good at coming up with arguments as to why there should be a more liberal approach than simply looking at the words of a contract. Because the best argument from an employer perspective is effectively, well, we agreed to this. Why sign a contract in any, between two parties, two grown-up parties doing serious business and having millions of dollars at stake? We signed this in a contract. You said you agreed that basically if you don't send a notice within X amount of days, you're not going to be entitled to something. And now you want to open all of that up. That really is kind of the best way for an employer to argue full time bar. And the arbitrators are alive to that issue, but at the same time, they don't want employers to hide behind this provision in order to simply bar genuine claims. But the claim does have to be genuine. It cannot be the fact that the contractor never knew about this. They simply never suspected that there is a claim, that there has been a delay, and then lo and behold, they finish the project. They realize that they need a bit more money to be in the black for the project, and they trawled through the past 5 years of the project trying to come up with various ridiculous claims, frankly, to get more time and to get more money out of the employers. So there is a better degree of, I would say, fairness, justice, equity, whichever words you want to use, but that certainly comes through an international arbitration, both for me as counsel and as arbitrator as well.
Mehmet?
So as an expert witness, my experience is to same extent. The number of cases, I mean, I can think of one, potentially two, depending on how you see the judgment, because it's not often just one point. There will be multiple reasons given, and you may consider lack of time notices was one of the reasons why the contractor did not get the entitlement. But I think in both cases, they were all three of them English arbitrators, very senior arbitrators, I will say. And in one of the cases, I remember well, the delay expert came up with, a number of delay events. It's not just even one. And, he came up with a critical path or critical cause of delay, totally different than what the contractor was contemporaneously reporting during the currency of the project. And then the contractor was just also relying on a fact witness to support that. There was really no contemporaneous notice, or let's say a piece of paper suggesting that the entire project was driven by these new manufactured, I will say, delay events. And I think the arbitrators came to a view that, well, there can't be a eureka moment where suddenly fact witness relies 3 years after the project completion. That issue was critical. So, I mean, again, it's a combination of issues, as Slava explained. They are looking at a number of points, bigger picture, and it doesn't add up, right? So they really, I think, they weren't really convinced, and of course, one of the reasons why they weren't convinced, because it is highly unlikely that there might be one or maybe two issues, but almost like the entire critical path or the entirety of the critical issues, rely on by the contractor at the arbitration stage was different than, what they were telling during the execution of the project. I think that was really probably one of the reasons why they thought there should be, or there must be a notice provided, you know, during when the events were happening. Of course, there might be a more strict view in England or in a court case than, let's say, an international arbitration elsewhere in the world, or even even in a, I would say, DAB, the views might be very different because the members of the DAB may be almost all of them non-lawyers, and they might just look at the practicality of the issues. For instance, in mediations, I know a lot of mediators will just say they just want to talk to the experts, not the lawyers, and they will not even consider, you know, whether a notice was provided or not. They will take it more like a, you know, commercial deal. So it really depends on, you know, the avenue of the dispute, I will say. But, you know, this is just from an expert's perspective. I'm not a lawyer.
Thank you, Mehmet. Natalia, something to comment?
Yeah, for example, I have not participated in an arbitration involving in time bar clauses. However, last year I was involved in a project dispute in Middle East where the engineer rejected all the UT claims from the contractor as a result of the contractor failing to comply with the 28 delay notice. At a later stage of the project, the employer did not agree with the approach taken by the engineer, because from the employer point of view was that the approach taken by the engineer was leaving him in a very high risk position in arbitration proceedings. Because they didn't want to go to arbitration, what they were going to not to succeed. They hire us, or they hire me or my company, to provide a fair assessment of all the EOTs presented by the contractor. Basically, the employer opinion was that the time bar clause strategy was not going to succeed in arbitration proceedings.
I see. So, well, let's end this with the main part and start with the last one, the Q and answers parts. Well, there's a lot of questions in here. I would like to answer any questions in the future, but later when we close. Now, if you would like to answer any of the already posted, proceed at your convenience. Any form. I have a general question for you. Easy to say. What other issues to the claim notices and liquidated damages do you consider could emerge in a case commonly encountered in international project disputes, whatever related to this, or directly you prefer directly refer to or some of the questions already published? But is there any issue to be aware of in international project disputes which deserve being mentioned here and now?
So if you like, I start this time first.
Right.
Just a change.
Just a change, sure.
Right. So again, as a delay expert, I'm often involved in liquidated damages related debates or arguments, maybe not only myself, but with the legal teams or clients' representatives. So I'll first start with the LDs. The hot topics or common issues now is determination of completion date or substantial completion date from which the LDs start to accrue, because one party, or especially contractors, argue that, you know, they substantially completed, employers start benefiting from that, so far, so on. That's one common issue, I will say. And then probably a little more, I will say, academic discussion is about the projects or contracts where the LDs are accruing concurrently. So let me expand that a little bit. Let's say you have 5 milestones and LDs attached to each of them, but actually some of those milestones are just interim milestones. So the employer will, or the owner will not really have any benefit if you achieve them in the middle of the project or not, but what they are interested in is just getting the final, let's say, mechanical completion or PAC, provisional acceptance. But when you look at the wording of the contract, the owner effectively has an entitlement to claim LDs from a number of milestones accruing at the same time. And obviously this results in contractor is reaching the cap for the LDs in a very short duration of time. Now, there is often an argument whether, even it's more or less clear from the contract provision, that's enforceable, and whether that's fair. So that's again a hot topic from my perspective. And maybe if we move away from delay a little bit, but consider the quantum, what happens if no LD is agreed, but there were delays to certain completion milestones, how the damages will be substantiated. So those are, I will say, 3 hot topics from my perspective as to the LDs. And with respect to the claim notices, one of the recurring issues is the formalities, whether, the formalities of the claim notice have been satisfied, and whether the applicable law of the contract provides some relaxations on those formalities. This will go back to the question about, or the point Slava made, what if you submitted your notice on a pink paper instead of the blue paper? So that's all. I don't know whether Slava, Natalia, do you have anything else to add on these topics?
Any of you, Slava, Natalia? Take the ball.
Well, continuing with the claim notices, I mean, what we see sometimes in arbitration is when, in the case that the contractor, they comply with everything, and still everything, the employer, they reject everything. Later on in arbitration, we as delay experts, we find themselves trying to make just making an opinion, or giving an opinion, providing an opinion if the EOT presented by the contractor were correct. If the procedure, for example, in Middle East, normally, according to the contract, normally we see that that the EOT need to follow a time impact analysis. We find ourselves just making an opinion, or providing an opinion if those time impact analysis were correct. So, yeah.
Anything to add, Slava?
I think I really quite like the discussion that we had. I think on on notices, it's the formality of notices. And the 2 scenarios, it's not necessarily about, pink or blue paper, but for example, if something is mentioned in a meeting, and let's say it made it into the minutes, but they're not signed by the employer, but it was clearly something that was said. Does that constitute notice in kind of a fair, equitable environment? Would a WhatsApp message from one project director to the contract administrator from the employer, would that constitute valid notice? And these are all kind of arguments that that I've actually seen being made. In fact, the WhatsApp one did get us across the line on the time bar point. So we were able to convince the arbitrator that that was sufficient to give notice. But, ultimately, lawyers such as myself and advocates in particular, barristers, our skill is to make the best out of our client's position. So we will twist the contractual language to suit the desired effect that we need to have. However, arbitrators are also very skilled at cutting through all of that and understanding the real issue and making a decision based partly on what is commercially sensible, partly on what is just and fair, and guided by the contractual language that they have in front of them. Because, you know, people tend to agree to certain things, and then later down the line, when it no longer suits them, this is when they try to say that, well, what I agreed to 3 years ago because I really, really needed to win this tender, you know, all of a sudden I don't like it. So let me try to pretend that I've never seen this and this is unfair and no one should ever sign this. You know, this kind of relapse in memory that does tend to happen. And sometimes it's the bidding team that agrees to pretty much everything, and then the execution team that comes in and has to live with it. You know, there are those situations. To me, the bigger and kind of more unresolved issue, which I'm starting to see quite a lot of, is employers taking possession, taking over or starting commercial operations of projects, and then saying that certain conditions were not fulfilled in order to reach the completion milestone. So whether this is, you know, RFSU for for oil and gas projects, whether it's kind of operational milestone for infrastructure projects. And there are really arguments that go both ways here, because from an employer's perspective, if I took a project which is severely delayed, and actually the LDs which I'm going to receive from the contractor in no way covered the losses that I'm making by lost production, and all of a sudden I take over this imperfect project at whatever stage, why should I not be allowed to levy LDs and insist on the contractor completing the project? So let's take, I don't know, let's take an oil processing plant, right? These things, they can process up to 300,000 barrels of oil a day. So we add, let's just say 2 zeros behind it. So that's $30 million a day that an employer could be losing per each day of delay.
Mhm.
Now they kickstart this kind of imperfect plant almost in manual mode, just in order to recover some of their losses. And then the contractor comes in and says, no, guys, this is it. You've taken over the works, therefore I'm off the hook, see you later. And by the way, all the warranties that I've given you, they're no longer valid because you've started the process. I think that is an interesting topic which is arising and is becoming more common to see. But I don't actually think that the industry, the arbitrators, or the contracts have an actual answer to this. I'd be interested to, you know, to hear the views of people either on from the panel or through the audience, through the Q&A.
Well, thank you, Slava. With your words,
I would like to add something with regards to the contracts. Also, sometimes you have the case that you mentioned, Slava, when the contractor, they mention something in order, they sign something in order to win the bid. Later on, 2 years later, they start complaining and making claims. Okay. But also, like 3 weeks ago, I discussed this with some colleagues from a main contractor here in Dubai, in the region, because they came to a meeting. And they were saying that when they go to sign EPC contracts with, with the main employers, the oil and gas one, they have to sign things that they are unbelievable. For example, they have to sign to sign that the quality of the gas or the oil, and it has this quality, and they don't have control. They told me that they need to, in order to win the contract, the job, they need to sign clauses that are totally unbelievable. So it is okay. The bargain power sometimes is not well balanced. So that could be the case. Okay, it's not black or white. There is like a kind of gray area that some cases the bargaining power of the employers are very high when compared to contractors.
Okay, Natalia, thank you. Well, with your words, I think we could close these Q&A answers, but there's still some room for last messages. First, we are approaching the end of this panel discussion. It was a pleasure to me to moderate the panel, the discussion, and the intervention of the audience. Indeed, this give a wide ranging impact of the topics on the discussion, and I'm sure we'll be hearing more than as we move forward. So now, before we leave in, I have answering some of the last queries posted by the audience. This recording will be available on social media in few days, and attendees will be informed about it to view in Ciarb YouTube account. And I usually try to send to the attendees of the events the Iberian chapter organized a link with a connection to see the video. Despite this, later on, Ciarb organized how to see this event in, as I mentioned, YouTube account, Ciarb YouTube account. For future events of our Iberian chapter, you could proceed in several ways, following the post of Ciarb webpage or public groups in LinkedIn Ciarb accounts. There are two in special: the general one public group in LinkedIn, and the specific for the European branch. I remember you that the Iberian chapter is part of the European branch. In case of that, you just ask your browser and internet to reach either of them. Naturally, if you get interested in being connected or comment, don't hesitate to ask for it or comment in the respective host. And last but not least, if you are, especially if you are a Ciarb member with a presence in the Iberian chapter local area and you would like to get involved in the activities of your chapter, don't avoid to let us know about you and to get connected. In case of doubt, you can always send an email to this email account, iberian.chapter@ciarb.org. Final words which I connect with the initial minds. Do you remember the FIDIC contracts standards, which was described as the suite of contracts was marketed as being practical contracts with common sense clauses incorporating the best in engineering practice? I've read and listened several times the word worthy related to the clauses, but is it clear for all that there are chances to not to get an answer the question, my first question in the very beginning, when late is late? Well, I leave you to answer yourself. I can mention to you that I've learned a lot listening to the speakers, learning from the intervention of the public, and I would like to express precisely my gratitude to all the speakers and the audience. Thus, I just say thank you all in the name of the Iberian chapter for joining us today. And to cut definitely, I would like to give the word to Natalia to close this event. Within his efforts and support, this would not be as well as it resulted. Of course, appreciation for Slava and for Mehmet in their comments, in their time invested with us, and hope you see you again sooner than later. Natalia, please close and say farewell to the audience.
Thank you very much for Antonio, for allowing me to do this event, but also I cannot forget about Abdelkader, who was the person who organized this event, and it was quite unfortunately he couldn't attend. And I am sure that it would be this event would be much more interesting with him, but okay, he couldn't make it. And for sure, thanks a lot for Mehmet and also for Slava for accepting the invitation to attend and to participate in this event. And I hope to see you to continue to continue working with you in the future. And yeah,
Yep.
Nothing to add.
Slava, Mehmet, something to say?
Thank you very much.
Okay.
And we hope to
Yeah.
see you soon again.
Mhm.
Just
So-
a big thank you to the speakers, the panel, to the Iberia chapter, and actually all of the audience. I think the questions actually challenged us today. I've
Yeah,
never typed
sure.
so much on a Q&A
Mhm.
on past sessions like this.
Mhm. Great success, I must add to all of this. Well, farewell to all. Enjoy the day. Enjoy the following days. Bye.